Hello everyone, I'm Jeff Hampton with the Fulgham Law Firm. Today I want to go over a video on a new video series that we're starting talking about, can a police officer make an arrest without a warrant? And by the way, if you wait around to the end of this video, I'll also give you a free ebook, What to Do If You've Been Charged with a Crime in Texas. All right, now let's jump right into this. Here's a question that comes up all the time, and I think it's a very valid one, and people want to know, can a police officer make an arrest if they don't have a warrant? Well, generally, the police do not have the authority to make an arrest of someone in Texas without a warrant. But if they do make an arrest without a warrant, then the police must be able to justify their actions and their decisions under the law. So here's one of the things, evidence, and there's two different ways to look at this. One is, do you have to have a warrant to arrest someone? And then there's, do you have to have a warrant to search, right? Two different issues. But evidence that was seized or statements that were subsequently made after an unlawful arrest may be suppressed. That is, in other words, thrown out of court. Now, I'm going to tell you, here's the crazy thing. I have seen it especially with narcotics agents and other situations that have come up. Sometimes police will choose to make an illegal arrest. They will just flat out do it. They're not really interested in gaining any evidence to charge that person. They're just trying to squeeze them sometimes in order to get information from them, knowing that they can't use any of the information, any of the evidence that they find against that person when they arrest them. But it's important to know what your rights are. So people say, well, what happens to me? Can I go sue the police? Well, I'm not even going to get into that because there's a very high standard and there's a certain amount of immunity involved if you're arrested illegally. Very difficult to bring a lawsuit against a police officer. However, the biggest thing that happens if you're arrested illegally is that everything that they take from you, anything, let's say there is something illegal that they find. Let's say that they try to want to charge you with something based upon that. It's not going to be admissible in court. All of it could be thrown out. And I'll explain how here in just a few minutes, okay? So here's the thing. The worst part about it is you've been unlawfully detained, right? Now you're being held. You're going through this horrible experience of being held by a police officer. And so the authority police have to make arrests is given to them by statute. So we have to look specifically at not only federal statute, but also Texas statutes. And so a police officer may arrest, here's the general rules, a police officer may arrest any person who is subject to arrest by a warrant. So obviously if an officer has a warrant, they can arrest you, right? But if they don't have a specific warrant signed by a judge, a valid warrant signed by a judge, there must be some legal justifications for it. So in some of those circumstances that we're talking about here, we have to say, here's how we do the analysis. Did the reason the police officer give line up with the statute? If the reason that the officers gave, and not just in a police report, but also the video, right? We got to see, anybody can write whatever they want in a police report. Does the video substantiate what the statute says is permissible for someone to be arrested without a warrant? And so one of the things a police officer must have to make an arrest, a police officer must have probable cause to believe that the person that they are arresting is committing a crime and that that person is in a suspicious place, okay? That's what they're looking at. Now, this assumes, first of all, if a police officer observes a crime in plain view, they have a right to arrest you, okay? They don't have to have a warrant. They can just see it and arrest you based upon that. But if they didn't observe the crime, there's more that they have to go through. What is probable cause? What is that? Well, probable cause is information that leads a police officer to believe that a person is committing a crime or is in the process or has committed a crime, right? That's kind of the standard. So it's more, you say, gosh, this is so subjective. It sounds very mushy. Like, how do we know what it is? Well, it's more than just mere suspicion. One of the things I'll find all the time is I've seen police officers just pull people over because they're coming out of a bar, right? For a DWI. That's illegal. Just a mere hunch, just to pull someone over for no reason because they're pulling out of a bar or a restaurant, that's illegal. So it has to be more than mere suspicion, but it doesn't have to amount to a preponderance of the evidence. It doesn't have to be something big. It doesn't have to be proven, that doesn't have to be an amount of evidence that is beyond a reasonable doubt. The rule, why was it created? It was created to strike a balance between legitimate law enforcement procedures and also keeping the public safe from making rash decisions. So in reviewing whether an officer possessed probable cause to make an arrest, the judge is going to look at, here's what the law calls, the totality of the circumstances, okay? That's the standard, the totality of the circumstances. So once the probable cause standard is satisfied, let's say the judge believes there was probable cause, then the police may make an arrest without a warrant if the person is found in a suspicious place. Now, what exactly is a suspicious place? You want to guess? The law says it depends upon the circumstances, right? Once again, kind of mushy here, where it's very subjective a little bit. So I'm going to give you an example. If the crime involves a motor vehicle, or if the motor vehicle is used as a means to commit the crime, then depending upon the circumstances, let's say an officer walks up and sees someone bent down, looking like they're trying to force their way in with something into a vehicle. Well, that position, being near a vehicle in the position that they're in, trying to fish something through a window, that may be seen as looking suspicious, right? That may be considered a suspicious place. So particularly if it's in line with where a police officer has seen crimes occur in the past, right? That's one of the standards that the officer is going to look at. So the location where the suspect is may also be connected to being a suspicious place. And so the suspect's behavior will play a role in determining whether the place is suspicious. It's kind of like I tell my son, if you go hang out in suspicious places, police are going to believe there's suspicious activity going on, right? That's how the police are going to look at it. So here's another strange thing. Let's say a person's behavior is odd. Let's say it's not in line with what a police officer normally sees. They're going to take what would normally look like a very innocuous location, and if they combine that with odd behavior, the police officer is going to claim that now constitutes a suspicious place. So a police officer may make an arrest based upon probable cause in other circumstances. For an example, let's say a police officer may arrest a person for an investigation for driving while intoxicated, if the crime is in the view of the officer. Now, the police officer doesn't have to see everything, right? He doesn't have to see every fact that gives rise to probable cause for the arrest, but he may rely upon other information. He can rely upon statements from witnesses. He can rely upon statements from other fellow officers that were involved. And so there are many circumstances where a police officer can make a warrantless arrest. But now here's the real question. What if you believe that you were wrongfully arrested and it was an illegal arrest? What recourse do you have? Can you file a motion? Can your attorney do something to try to have that arrest thrown out and any charges? Absolutely. It is known as a motion to suppress, okay? A motion to suppress is a type of legal maneuver where your criminal defense attorney can file it with the court that your case is assigned to and essentially call witnesses to the witness stand, including the police officer himself, and use the videos and the police reports to establish that the justifications that were given by that police officer do not match up with both state and federal law to be a legal arrest. And you can actually get two bites at the apple on this. And I'm going to use that at DWI as an example. One of the ways we've had DWI trials in the past, we had a particular client that we represented that the police officer basically pulled him over for no reason. Now, the officer believed that he claims in his report that he pulled him over because his front headlight was out, right? So he claimed that his front right headlight was not operating properly. Well, guess what happened? We go and look at those videos and we take a look, and sure enough, as our client is pulling out of this mall area, you can see him turn in front of a window pane where you see windows, and what do you think we saw? We saw two headlights, okay? We could see two headlights shining bright as could be into that window pane. Now, it reflected back and it was caught on a video. Now, the question becomes, what do we do? Well, at that situation, we had two opportunities. We could file a motion to suppress to have the issue heard in front of the judge, and the judge could rule that the actual stop was illegal, that there was no reasonable suspicion for the stop, and if the judge ruled in our favor, then there is no probable cause for the arrest and the entire DWI is thrown out of court, okay? But what if the judge agreed with the police, and what if the judge allowed the case to continue on to trial? Now we can make an argument to the jury itself. We can actually make an argument to the jury that, okay, hold on a second. Even if our client was intoxicated, It doesn't matter because the arrest was illegal. And in this particular instance, that's exactly what happened. Even though our client was a 0.18 blood alcohol level, whenever we were able to clearly show that to that jury that there was headlights and there was no legal reason to pull him over, at that situation, the jury came back and found the client not guilty of DWI based upon an illegal stop. Okay, so here's the point. This is one of those areas that needs to be looked at, both as it relates to a stop, because it also affects the arrest. If it was a warrantless arrest, then it's very important that the police follow the procedures and the protocols as it relates to this situation, all right? Now, maybe you are facing a situation where you feel like you were wrongfully arrested. Maybe you don't believe there was probable cause for your arrest. And maybe that case is out of the North Texas area. Don't hesitate to contact the Fulgham Law Firm at 817-877-3030, and we would be happy to give you a free case analysis and a consultation. And I promised you if you waited around to the end of this video, I'd also give you a free ebook, What to Do If You Have Been Charged with a Crime in Texas. Just click the link below and I'll be happy to send it over to you. And if you liked what you heard today, like our video, subscribe to our channel, and we'll be happy to send you more great content just like this. Thanks again for joining us. We'll see you next time.